So, good morning from the South Hemisphere. Good afternoon, I say, from the North Hemisphere. We're very happy to have you today to speak about arbitrating future tech disputes in this CRB event, where we are very happy and proud to welcome our wonderful panelists, Ricardo Campos, partner at Opus Bloom, Bruno Vanisov in Brazil, and lecturer at the Goethe University at Frankfurt am Main in Germany. Matthew Levy, barrister, André Gusco Cardoso, LLM at the University of Paraná, and partner at Justin Pereira Oliveira Talamini in Curitiba. And Elizabeth Chan, registered foreign lawyer, England and Wales, working at Allen Overy in Hong Kong. And of course, my co-moderator, Celso de Acevedo, barrister at the 36 Commercial part of 36 Group. And so welcome everybody to the CRB event. We're very happy to have you here today. And without further ado, I would like to start with the first question. So my first question to all you panelists today, just to open this event, would be the following. Does arbitration have a role in blockchain disputes? So let's speak about a review of the UK Jurisdiction Task Force New Digital Dispute Resolution Rules. So does arbitration have a broader role in digital disputes? Matthew?
Yeah, I would say, so starting with this question, does arbitration have a role in blockchain disputes? I'll let others speak more broadly. I think the answer is absolutely yes and absolutely no. In other words, it all depends. I want to start because I think it's convenient to think about where it does not have a role. So I think, not everyone agrees, but I think it doesn't have a role in the most common form of blockchain disputes that we're seeing in court at the moment. And that is because those disputes typically arise from fraud. The sort of thing I have in mind is a dispute where someone's been tricked into handing over a crypto asset, or bought something worthless under false pretenses, or perhaps had their wallet hacked, had their assets stolen. Now, it's difficult to see a role for arbitration in those sorts of disputes because you don't have a willing counterparty. You don't have an arbitration agreement or an obvious way of getting an arbitration agreement. Often you don't even know who the defendant is. And in those circumstances, the court mechanisms of allowing you to sue, certainly in the UK and many other jurisdictions, unknown defendants, so-called persons unknown, is actually needed. And it's not obvious how you can do that with an arbitration. So really that comes down to the same old problem. Where's your arbitration agreement? There's another issue here. In order for an order or an award or something to be useful in those sorts of circumstances, you have to be able to wave it in front of third parties, such as exchanges, such as wallet providers, and say, look, I've got a court order, please freeze those wallets. Now, if you try and do that with an arbitral award, let's set aside confidentiality for the moment, it's not going to have the same effect because people are going to look at it and say, all terribly interesting, what's that? So what do? You go to the enforcing court, you convert it into a court order, but by then the crypto has long gone. So that is not a practical approach. So that's the negatives, that's the no, why bother with arbitration? There are actually plenty of other disputes where I think the role for arbitration is much more promising. Take a dispute between crypto asset holders and their wallet providers, or between purchasers or sellers of assets and exchanges. That is generally a contractual relationship. Why not have an arbitration clause? Where you have, say, a crypto investment scheme, the relationship there is very often contractual. So again, why not have an arbitration clause? And of course, blockchain-based technology is increasingly being used beyond the crypto asset space and fulfilling other commercial functions. And again, contractual framework is the norm, so have an arbitration clause. There's a huge advantage to arbitration in some of these sorts of contexts. Firstly, you have the usual point, confidentiality. That can be important to people who are playing in this arena, people who are investing and engaging in the blockchain space. The flexibility and agility of arbitration can be very attractive in a blockchain world. And of course, with appropriate tribunal rules and powers, there's scope for innovative remedies that are specific to those environments. And that really brings me to the UKJT digital dispute resolution rules. It's important to briefly provide some context here. So the UK Jurisdiction Task Force is, I suspect, not necessarily known to people listening today because it's a UK-based thing. It's part of something called LawTech UK, which is a government-backed initiative for supporting transformation of the UK legal sector with technology. The focus is technology. And the UK Jurisdiction Task Force part of it is designed to try and make our jurisdiction well equipped to deal with blockchain-based disputes and thereby make it a good place to develop and deploy blockchain technologies. The first major publication of the UKJT was something called the Legal Statement of the Status of Crypto Assets and Smart Contracts. I was heavily involved in that myself. And the purpose of that document was to set out clearly what crypto assets were in English law and what smart contracts were in law. And we analyzed those very modern creatures, crypto assets and smart contracts, by reference to very conventional law and well understood legal concepts, the law of contracts, the law of property. And we tried to analyze how one maps on to the other. Now, that legal statement's been subsequently endorsed by lots of courts, both in the UK and elsewhere. And it's really the foundation for the UK Jurisdiction Task Force's work. Its most recent publication is these digital dispute resolution rules, much more procedural in concept. What they're meant to do, they're designed to be incorporated into on-chain digital relationships and smart contracts to provide for quick, efficient arbitration of those disputes. And the first thing they do, which I think is quite interesting, is they provide an express provision that the outcome of automated dispute resolution, for example, on-chain, but not necessarily on-chain, is legally binding. So it removes all doubt about that. The second thing they do is they say, if you don't have automated digital dispute resolution, then arbitrate it, conventional arbitration. And we have some arbitration rules. They're very light rules. They're deliberately, it's a very light procedure. It's a flexible procedure. The arbitrator or the tribunal, if it's 3 appointed, can basically do what they want within reason. But the key point is best endeavors for the tribunal to determine the dispute within 30 days. And then there are, I'm running out of time, but a few points of particular interest in these rules, which I think are worth considering in any other set of rules that, for example, you might be coming up with. Firstly, there's Article 11. That is a specific power to operate, modify, sign or cancel digital assets relevant to the dispute. So you're giving your tribunal specific powers to play with keys and specific powers to require a party to exercise their crypto rights, to sign things, to use their keys. Then there's Article 13, which is party-party anonymity. So if you have a world where people are interacting on-chain pseudonymously or anonymously, that doesn't preclude this arbitration, because the way it works is the parties have to tell the institution and the arbitrators who they are, but they do not have to tell each other who they are. So you can have, as between the parties, anonymous arbitration, which can be very attractive for some people in this space. Finally, of interest for now, there's a power to publish awards unless there's an objection, anonymized. So the idea is over time to try and bring some sort of jurisprudence to this area. It's all very, very new. I can't tell you how it's playing out because it isn't really yet, but it's a model that I'm very excited in, and I'm very interested to see how it develops over the next few years. I've spoken more than enough. Someone else to add to that, please.
Thank you, Matthew. This is all very interesting. Thank you for your very deep and instructive answer. We would like to hear from Lizzie. Lizzie, what is your opinion and position on this, please?
I agree with Matthew that the UK digital dispute resolution rules offers a very interesting model. And why I think it's interesting is we're really thinking about dispute resolution from the perspective of users' needs. So, you know, one of the strengths of arbitration, as Matthew pointed out, is its flexibility. And I think it's important for dispute resolution procedures to reflect the dynamic in which disputes arise. And so Matthew has already mentioned that, for example, to reflect the fact that parties can transact anonymously on the blockchain, the digital dispute resolution rules allow the parties also to arbitrate anonymously, at least vis-a-vis each other. I think more and more we need to think about what users need. I think the UK digital dispute resolution rules go a long way to meet users' needs, but there might be other ones as well. Arbitration might still be considered expensive and costly. And one of the alternative dispute resolution systems that I've been looking at recently are decentralized justice system. I confess I haven't actually myself had I haven't had personal experience with using decentralized justice platforms like Claros, Aragon, Jure, and many other platforms, but I think they offer a very interesting dispute resolution procedure for users in digital disputes, and offering a dispute resolution system that is effective and fast. I think we need to think about what impact this has for us as practitioners in arbitration. Like, we may be used to high standards of due process, that might not be the same that might not reflect the expectations of users in digital disputes who are looking for something faster and rougher and looking for a decision that's good enough.
Well, thank you, Lizzie. I think the time will come very soon when we all have experience in these platforms. And we would like to hear Ricardo's insights regarding this matter. Ricardo?
Thank you, Carmen. Thank you, Celso, for the organization. So I think Elizabeth and Matthew, they informed us a lot about the blockchain dispute and the horizon of it. And I'll take some observations on the second question posed by you, Carmen. If arbitration have a broader role in digital disputes. And it's quite interesting to see that in recent years, the rise of internet. I'm a lecturer here in Frankfurt, and I teach tech law. It's quite interesting to see that in digital societies have posed challenge to the ordinary court disputes. So the power of technology to resolve disputes is not only exceeded by the power of technology to generate disputes. And these disputes can involve startups, middle market companies, even and frequently companies like Apple, Google, Facebook, among others, that are engaged in some ways in disputes that involves dozens of related cases in various courts and continents. And these disputes involve small claims of consumers or data subjects against the companies more frequently than not. And in this sense, Carmen, over the last couple of years, new projects arising from this field called decentralized justice are giving new air to this industry and bringing some kind of innovative way to provide a fast and affordable dispute resolution procedures for these small value claims in the digital economy. And just to conclude, in this sense, I think this field is a kind of result of a convergence of online dispute resolution, blockchain, and international arbitration and legal design. And also in this sense, Celso, UK is really far. If we compare with Brazil, we should discuss and bring this approach, UK approach, and the discussions that is being leading from UK. We should in Brazil take it more seriously than we have done until now. Thank you, Carmen.
Thank you, Ricardo. This is posing a huge challenge for us here in Brazil, and exactly the time for André to comment on this as well. André, please.
Yeah. First of all, thank you for the invitation, for CIR, Carmen and Celso for the invitation. And as being preceded by all the panelists, I will try to make a summary of all the ideas and bring some new ideas. When we examine the suitability of arbitration to solve and to settle tech disputes, we need to know that arbitration also evolves and needs to evolve. Traditional arbitration should catch up with tech, and there are all discussions on this. Arbitration as a traditional method of dispute resolution is evolving too, is also evolving and trying to we could mention that it's behind tech, but with time it will catch up with tech. Smart contracts, for example, autonomous systems will demand a new view on arbitration. Some disputes will be settled by arbitration. So other disputes, consider their nature, will be settled by ODR systems or distributed justice, as Ricardo has mentioned. And the countries and all the legal systems will have to adapt to this new world, this new world of tech, new disputes of tech, and new reality that is posed by technology, new platforms, and even smart contracts and autonomous systems. And considering all this, we can say that arbitration seems more suitable to solve tech disputes. Arbitration in the traditional form of or in an evolved form, but some kind of arbitration is more suitable to solve tech disputes because of the flexibility and all the characteristics that usual and traditional courts doesn't have, and have more time to evolve and to develop. Arbitration could evolve more rapidly, more with speed, with the speed needed to catch up with tech. These are the closing ideas on this. I don't know what everyone thinks.
Well, thank you very much, André, for this, and you are just advancing on the question I had next for all you panelists, and it's exactly that. Are tech disputes really better dealt within court proceedings than in arbitration? Does everybody agrees with this statement from André? What do you think, Ricardo?
Thank you, Carmen, for the question. I would just make a short comparison between a German approach and the Brazilian one. There are we know that are difficult with litigating in technology disputes, particularly where these disputes are global and involve rights protected in different jurisdictions. That's the case, for example, intellectual property, media regulation. We have now in the European Union, the DSA, which introduced a new kind of dispute resolution for this new opinion industry, and have also the case of data protection and all these technology disputes. And maybe unlike usual contractual disputes, can arise between parties who have had no previous relationship. And I see that's a quite interesting challenge for the arbitration or for dispute resolution, because it could involve an immeasurable number of parties affected. And further complicating the issue is that these rights involved in tech disputes are generally provided by different national legislations, and that's really a huge a challenge for arbitration. And just to pick one example from German, we have in Germany the German Association of Law and Informatic as a conciliator in arbitrator procedures, and it operates a conciliation office to resolve dispute relation to, for example, to information and communications technology by the way of mediation, conciliation proceedings, and if necessary, also arbitration proceedings. And the conciliation team consists of an IT expert and a lawyer qualified in IT law. That's quite an interesting development. And in Brazil, just to finish my answer, in Brazil, we have a recent guideline provided by the National Data Protection Authority that established that small companies should seek solving the data subject's claim through alternative methods. So, for example, small agents can organize themselves through business representation entities, by legal entities, and by natural persons for the purpose of negotiation, mediation, and conciliation of complaints filed by data subjects. And I think this new development shows that we should, in tech disputes, try to go away from the courts. In order to be more, as Elizabeth put it out, to be more efficient, to be more fast in the resolving the claims, and so on. Thank you.
Thank you, Ricardo. And I would like to hear to Elizabeth's thoughts on this subject. Please, Elizabeth.
Thanks, Carmen. And just building on what Ricardo said about the advantages of arbitration and moving away from the courts, I thought I would answer Carmen's question about which forum is most appropriate for resolving disputes by sharing some information about surveys of users. So interestingly, 2 surveys recently have found that companies in the tech sector generally prefer arbitration over litigation for resolving tech disputes. That's not necessarily uniform across the sector, but the surveys that I refer to are the 2016 Queen Mary University of London survey, which reported that 92% of respondents considered international arbitration to be suitable for resolving technology, media, and telecoms disputes. And the attractive features of arbitration included enforceability, the ability to avoid a foreign jurisdiction, expertise of the decision maker, and confidentiality and privacy. Now, these findings were largely also reflected in the 2017 Global Technology Dispute Resolution Council and Silicon Valley Arbitration and Mediation Center survey. And there it reported that the ability to choose a specialized expert decision maker was one of the most attractive features of international arbitration. The disadvantages of the courts were seen as cost, followed by lengthy proceedings, and judges having limited technology industry and technology law expertise. So that's sort of an overview of why users might prefer international arbitration. But I think something we should remember also is that tech still continues to form a relatively small part of commercial arbitration. So when I've looked at institutional statistics, I think energy and mining and resources continue to be the most popular sectors for using international arbitration. So if I can share some statistics. So for example, the ICC reported for its cases filed in 2020, 5 to 7% of them came from other sectors. And this was really a catch-all, which included telecommunications and specialized technology. It's not clear what of that 5 to 7% were tech-specific only. The Hong Kong International Arbitration Center reported that for 2021, 4% of its newly registered cases were IP disputes. There was no separate category for technology. The Singapore International Arbitration reported in 2020 that parties filed cases in various sectors, including technology and science. But again, this category fell within other sectors, which would have included many other different sectors in addition to technology. And the LCIA reported that for its 2020 caseload, 2% of its cases arose out of the technology sector. So in conclusion, what are we seeing here? We're seeing one, that users in the tech sector think that arbitration is useful for resolving tech disputes and may prefer it to litigation, but in practice, technology disputes seem still to form a relatively small, even if an important part of the caseload of institutions.
Quite interesting, Elizabeth. Thank you so much for that information. Matthew, what are your thoughts on this?
Well, I can't possibly follow up after that deluge of information. What I will say is this. I mean, going back to what Ricardo was saying, very interesting to hear about all these court schemes that have been appearing to deal with tech disputes. And of course, the intention, and this happens in a variety of jurisdictions, is to make things more attractive. And what seems to happen? Everyone runs for the hills. They go to arbitration as these new court schemes come in. But more seriously, which is better? I mean, obviously, there are advantages of arbitration. You've got the possibility of efficiency. You've got more of a chance, sometimes at least, in some jurisdictions, of cost control. But actually, I think the most important thing for parties most of the time is to get the right answer, or to put a slight gloss on that, to get an answer that the losing party can live with, so that the losing party thinks the process has been fair, because let's face it, the winning party is always happy. And how do you get that fair outcome? I mean, to me, it doesn't depend on whether you arbitrate or whether you litigate. What it depends on is the decision maker. And the decision maker can be a very good one if it's a judge, and it can be a very good one if it's a tribunal. It can be a very bad one if it's a judge, and it can be a very bad one if it's a tribunal. So I do think that you're making sure you have competent, qualified, and frankly, just good decision makers is the number one goal. Sometimes there is more flexibility to manage that with an arbitration, but in some jurisdictions, you can be pretty confident of that in court as well. It all depends. Now, I was very interested, Lizzie, in the QML survey that you mentioned, and this idea that 92%, I think you said 92%, of sort of tech sector participants want arbitration. Now, of course, that's a very large percentage. But of course, what's quite fascinating about that is that generally, of course, there are disputes as between participants in the tech sector, but an awful lot of their disputes will be they are the supplier and they've got a client on the other side. I would love to know if their clients take the same view, or is just this a function largely of suppliers not wanting their dirty laundry aired in public? I don't know. It's just a question.
That's an interesting point. I think we'll come to it later when we're talking about mass consumer disputes as well, and where tech suppliers would prefer those to be resolved. And often that answer may be not resolved, at least in any mass action or class action.
Very interesting. Thank you, Matthew, for that. And last but not least, that we would like to hear to Andre's thoughts on this matter. Andre.
Thank you. And I pick up from Matthew's claim on we need a good decision making. We need good decision. Someone who's capable of a good decision, arbitrator or traditional courts. And in some cases, some tech disputes are only you are only able to enforce the award, enforce the sentence in a traditional court. And I bring two examples, two anecdotal examples of the Brazilian courts using their full force to enforce some judicial decision in this case. The first one, and probably you have heard about, it was about 2016. It was the blocking of the WhatsApp app in Brazil. In a criminal case, a Brazilian judge ordered the blocking of the WhatsApp application in Brazil because WhatsApp was not was not complying with the court order. And more recently, and this trend afterwards, the Brazilian Supreme Court reversed this court order, this lower court order. But more recently, we have a new episode, and everyone probably heard about it. It was the blocking of the Telegram app by the Supreme Court, by the Brazilian Supreme Court. In another criminal case involving discussions on fake news and use of the platform to manipulate political masses and political thoughts, the Brazilian government, the Brazilian Supreme Court ordered suspended the Telegram app in the Brazilian territory. Afterwards, the order was reversed, but Telegram has to comply with all the court orders, and it was very the repercussion of this decision was very big in the international press, even in Financial Times. And this kind of discussion show us that some kind of decisions and some kind of enforcement procedure and enforcement tools we can resort only to traditional courts. Arbitration could not done with this, and even arbitral awards could not be enforced by courts with the same force. Probably both these decisions were the result of the court being diminished by the non-compliance of the litigation of the plaintiff. Thank you.
Thank you very much, Andre. We are going to continue with the theme of what is the best adjudication system? What is the adjudication system that the losing party, as Matthew mentioned, can live with? We'll feel that it is a good system. We are going to now move on to the next question, which is, I think, for me, the most interesting question of them all. But they're all very interesting questions. But I think that this takes the prize, because it really shows how complex the analysis is, because we are going to now move on to the question of, should the tribunal appointed experts be avoided in tech disputes? And of course, that depends on whether the tribunal appointed expert in an arbitration will be appointed within a common law system or within a civil or Roman law system. The way that the appointment of experts by tribunals is carried out depends on the culture, the legal and procedural culture of the seat of the arbitration. And I think that Ricardo has some thoughts for us on this. Ricardo, please.
Thank you, Celso. That's quite interesting question. Maybe you can use the comparison between Brazil and Germany again. So as we know, arbitration procedures held in Brazil can heavily be influenced by domestic litigation rules, such the Brazilian code, civil code procedures remains a kind of implicit source of influence, and also culturally. One could say that we have also an implicit influence of the French arbitration tradition. As an underlying rule to arbitration, the code established, for example, that when necessary, a technical report must be produced by a tribunal appointed expert. In this situation, the judge should nominate an expert that he or she trusts. The first problem, as you maybe Sean put it out, Celso, is that these circumstances is could increase the expense for the parties. Not only with the parties have to bear with the cost of their own experts who are indispensable for the proceedings, they will also need to pay for the expenses incurred by expert nominated by the judge or arbitrator, as this approach in commonly adopted in domestic arbitration. And second, the proceeding will last longer. Last but not least, the tribunal appointed expert is usually chosen from a list that does not necessarily include the most capable or the most informed professionals on the specific topic. And if you make a kind of comparison with Germany, overall, in German, arbitration law is surprisingly arbitrator-friendly and flexible when it comes to party-appointed experts. And then there is no obligation of the tribunal to appoint a neutral expert in the case of contradictory party-appointed experts. And this is a very, very important to accommodate the practice of international arbitrations where party-appointed experts and awards based on contradictory party-appointed experts are common and accepted. I think that would be a kind of cultural difference between Brazil and Germany. And I hope I could, in these 2 or 3 minutes, being clear enough to sketch it for the public. Thank you, Carmen and Celso.
Very interesting, Ricardo. So it seems as Germany seems to be more friendly towards party-appointed experts, and then a tribunal award being made without a tribunal-appointed experts being part of the proceedings. Andrea, you were going to give us some of your thoughts on this as well, please.
Of course, thank you. And the great problem with tech disputes, it's that tech disputes demand timely decisions. It was not for an other set of reasons. There is also the risk of obsolescence in certain kind of disputes involving tech and involving some kind of patent disputes and some disputes related to tech like this. And the appointment of tech experts by the arbitral tribunal involves time and additional costs. And this, unfortunately, this is the role, this is the main role and the experience we have in Brazilian arbitrations we sit in Brazil. In Brazil, arbitral tribunals are composed by, in general, by lawyers. Usually, the composition of the tribunal is by lawyers. It's hard to find a tribunal that's composed by by an expert on the team that's been disputed. And this is a trend. This is a cultural reason, but this is a trend that could be related both to the legal tradition in Brazil, even the idea of the lawyer, of the attorney as someone that has and deals with procedures, deals with laws, and this is still very, very strong in Brazil. But this trend could be related also to future judicial challenges and their parameters. To traditional courts, it's difficult to see a non-lawyer, a person that has no legal formation to settle a dispute, and this is awkward to traditional courts, and probably this is the reason why in Brazil. Most, I don't have the numbers as Lizzie had the numbers, but probably if we could make a survey on this, we could we would see that more than 90% of the arbitral tribunals and composition are composed by lawyers, by persons with legal formation, and this is a trend that has to change in order to evolve to settle tax disputes too.
Very interesting, Andrea. I remember myself, you know, a good 10 years ago going to Chartered Institute Arbitrators seminars, in which the president of this CIAB at the time gave a whole lecture saying the advantages of having complete tribunals with no lawyers in it, you know, which was a much better tribunal to get to decisions. But that's very controversial thing to say. I remember even then was very controversial. So let's see what happens in the future in Brazil. But Lizzie, you were going to give us some of your thoughts as well, please.
Yes, I agree with Ricardo and Andre that cultural differences might explain how willing parties and tribunals are to allow for tribunal appointed experts. So perhaps an adversarial system, so those who are used to adversarial systems might be more reluctant to have tribunal appointed experts. And I find this interesting because one of the statistics that I raised earlier was some users or a large number of users think that arbitration is suitable, particularly suitable for resolving tax disputes, because you can choose an arbitrator who has experience, specialization in tax issues. But then why is it then, as Andre pointed out, do we still most commonly see tribunals that are composed entirely of lawyers who may not be subject matter experts? And I think one of the explanations is that we are just trying to optimize for many things when we are selecting an selecting an arbitrator. So even if you picked an arbitrator who had technology expertise, perhaps they might lack experience in other areas, for example, just experience arbitrating international arbitrations, or you don't know what their reputation is for making robust decision making, for making robust procedural decisions, which you may think is more important ultimately for your strategy and case. So while I suppose in theory it is useful, it is useful to be able to select an arbitrator who has subject matter expertise in particular in tax. Ultimately, when you select an arbitrator, you might still end up picking a lawyer with the general experience, because ultimately it's that experience in international arbitration that might matter more. And you might be concerned also if you have a multi-member tribunal, that if you pick an arbitrator that has expertise in tax, you might think that, well, perhaps they may not be able to persuade the other tribunal members to their point of view anyway. So you ultimately choose an arbitrator that maybe a known quantity, someone who you think can really carry the tribunal, persuade the other members in a particular decision. So those are my thoughts.
Thank you, Lizzie. This is very true. Matthew, what are your thoughts, please?
Well, from someone who comes from an adversarial system, the notion of a court-appointed expert is a very unusual one, certainly not one I have a great deal of experience of. But can I raise a related point? It's been touched on already. And my question really is this: what subject matter expertise do we think is actually needed to decide a tech dispute? And the answer to that, of course, depends on what you mean by tech dispute, because I mean, in the real world of actual disputes between parties, there are contractual disputes where people are arguing over what they agreed. There are technical disputes where people are arguing over whether the system, let's say, does what it's meant to have done. There are intellectual property disputes where people are arguing over the infringement of rights. And those things can involve very different subject matter expertise and actually skills. And There are some, of course, there are some disputes where the actual technicalities, the technical expertise is what really drives the outcome. But in my experience of about sort of 18 years of doing almost exclusively tech disputes in the broad sense, I can probably count on one hand the number of disputes that really turned primarily on the technical evidence. So I don't know, that doesn't really answer the question, Salso, but it's as good as it gets from me.
No, that's very good. I think that it is all a developing field. So I think that until, as many of you said, we have greater measurement of what has happened, in truly detailed surveys, we can only guess based on our anecdotal experience. Which takes me to the next question, which is, does arbitration have a role in mass consumer tech claims? I think this is a very important area of development, as some of us have mentioned, particularly bearing in mind all the cryptocurrency exchanges are out there and how the consumer legislation interacts with arbitration, which is a very difficult area. So Lizzie, you are going to give us some of your views on this, please.
Yes, thank you, Tesla. And I think the answer to this question is maybe arbitration has a role in mass consumer tech disputes. Sometimes it will be in the courts, and actually the question of where mass claims should be decided in which forum is often an issue that arises in this context. I think first of all, it's important to recognize, in what context might mass claims or class actions arise, and I can already think of a couple of examples. So one would be violation of personal data, for example. So we're really thinking about like the disputes involving users and tech providers. So one example is, for example, users of WeChat, the Chinese language communication platform. Users of WeChat brought a class action against WeChat for the alleged misuse of privacy data. And Tencent argued in December last year that WeChat users should be required to arbitrate their data privacy claims in Hong Kong. So that's one example. Other examples of the class actions or mass claims involve claims by minors. So for example, involving Valve Corporation, Valve prevailed in 2 arbitrations against parents and children who argued that Valve concealed that their games included gambling elements in violation of Washington law. And the arbitration found that Valve did not facilitate gambling in their games. And then the parents whose children, the parents involved in this litigation later sought classification in Washington federal court. So we see the interplay between arbitration and litigation here. Another example is in March last year, the Northern District of California granted Sony's motion to compel arbitration in a class action involving minors who spent money on a game called Fortnite. And the court found that the named plaintiff's claim fell within the arbitration clause. So really a big lesson here is that users should be aware of the arbitration clauses that they enter into. And what about the future? What other subject matter of mass claims might we see? I already mentioned data privacy. I think in particular when thinking about the metaverse and the use of immersive technologies, the success and effectiveness of those immersive technologies really depends on collecting a lot of personal data to make your experience in virtual reality as real as possible. I can see potential disputes arising in that context. Another example is purchase of digital land from metaverse platforms, for example. Like users might bring claims against metaverse platforms if they make some changes on the platform that affect the value of the land that they've bought. So those are some of the disputes that might arise, but what are we seeing? What is the response of tech providers? And what we've actually seen is that many tech companies already anticipate the possibility of mass claims. So a number of them include in their terms of service class action waivers. So that's true if you look at the the terms of service of Decentraland, Oculus, Roblox, Binance, OpenSea, and MetaMask. That's just a few examples. Now we need to understand that, like, notwithstanding these class action waivers, their validity and enforceability will depend on the application of domestic consumer legislation. This will depend on the court before a claim is brought, the nature of the claim, etc. It will, the interaction between the interaction with domestic consumer legislation will be something really important to take note of. And then just finally, like, what are some examples of mass claims that we have already seen in the arbitration field? One is the finance arbitration. So in August 2021, last year, was reported that Lissy Capital, a third-party funder, had proposed to fund a class action style arbitration involving 700 plus potential traders as claimants. And the circumstances of the dispute arose out of a shutdown of many parts of the Binance online trading platform on a particular day, which had one of the largest percentage drops in value of Bitcoin ever, and the fact that traders couldn't access their accounts on Binance meant that they lost a lot of money. And so that's an arbitration claim that we're looking at the moment. And I won't go into detail because I see time is running short, but class actions have been brought against Binance and Coinbase in the US as well.
Thank you, Liz. Exactly. It's very interesting to see. It's exactly what you said. The question is how the domestic jurisdiction, the domestic legislation enforces consumer protection legislation against arbitration clauses in these big tech contracts, and how broadly it classifies what is a consumer. Is a consumer only an individual, or is a consumer be a company, a small company as well? And if so, what is the minimum turnover? It's very interesting to see how this area will develop. Matthew, you're gonna give us some of your thoughts, please.
Sure. I mean, on that point, again, it's interesting, isn't it? The way that certainly in Europe and the UK, consumer rights legislation would tend to look horrified at arbitration clauses for consumer contracts, or at least let's be careful what we mean by this, would look horrified at clauses that bind consumers into only pursuing their remedy through arbitration. That's not quite the same as saying arbitration clauses are in and of themselves horrific. You could have a right of a consumer to choose, and that would, I suspect, often be perfectly palatable. And what's interesting is that this sort of starting point, which I think we all implicitly assume on this panel, the legislators assume that arbitration clauses against consumers are dreadful things. What will be quite interesting is to see if you give consumers a choice, some of them might actually choose arbitration because it might be cheaper. In some jurisdictions, it's going to be hugely quicker. If people have done something stupid online, they may not want the public forum of a court to deal with it. And there are all sorts of reasons why actually for consumers, it could be a jolly good thing. And indeed class actions by way of arbitration could be a jolly good thing because it's a way of funding, isn't it? It's what you might otherwise either not be able to afford yourself or more plausible if, I mean, Lizzie raised the obvious one, which is the sort of data type claim. I mean, you're just not going to go down the route of trying to claim for, say, $500 or something. It's not worth the hassle, the aggro, the time, the cost. So let's just throw away this notion that it's always necessarily bad, and let's imagine there are some advantages, particularly for lower value disputes. I mean, I think the real challenge for me is the procedural barriers. How do you actually do it? I mean, you can't, well, there's no obvious mechanism for an opt-out class arbitration action. So it's a US style class action where you have a representative who claims on behalf of the entire class, which is obviously a great thing if you want to get third-party funding and things. because I mean, how do you actually do that? So, do you have a multi-party arbitration clause? Or do you simply have lots of bilateral arbitrations, but with rules that allow automatic consolidation? You know, what are the mechanics? And one of the downsides of arbitration sometimes are these things we take for granted in court, because there's always just a rule to sort it all out. Can be, you know, really foundationally disastrous in an arbitration. So I think there's work to be done if sort of the class actions are going to work via arbitration, to work out a set of, well, A, rules, but B, more fundamentally, what do the arbitration clauses look like to ensure that they work? How are they going to be enforceable at the end of the day? I mean, the Binance arbitration is quite an interesting one. I mean, one hears an awful lot about it, or about the fact of it, but I personally know very little about the detail of it. I mean, how do the arbitration clauses work? Was that a consolidated set of independent arbitrations? And you know, what was the power of consolidation? How was it made to happen? So where do we end up? I think very interesting idea. I think it's something that consumers might really love in the right context. I'm yet to see a clear articulation of how you do it and make sure you have an arbitration which isn't broken, which works procedurally and is enforceable.
Very good point, Matthew. I certainly have had experience of difficulties in consolidating arbitrations, and it depends, in my experience, it depends a lot on the institutional rules. If there are institutional rules that already state that the tribunal will have the power of consolidating similar disputes, that's very helpful. If not, you're going to have to fall back on the legislation, the arbitration act of the seat of the arbitration, and whatever is the experience of the court in that jurisdiction dealing with this type of requests for consolidation. So the procedural issue is certainly a difficult one. But André, you were going to make some comments on this as well, please.
Yeah, and I will present some specific aspect of this discussion that is related to ODRs and mass claims. And to this, we need to differentiate usual daily mass claims, or we can say the routinely disputes between the consumer or a party and a platform or a technology provider, from the mass claims from the class actions. The class actions are usually related to big events, big circumstances in which a tech platform or a provider has made something not wrong, or something that was not correctly according to a law system. And arbitration seems more suitable to solve this type of disputes, like class actions related to tech claims. But the usual, the day-by-day disputes between users and tech platforms and tech providers seems to be more suitable to ODR systems, or systems that provide distributed justice, not arbitration, and not traditional courts. We need to think about everything in the panel. Probably agree on everyone in the panel agrees on this. That is, we have a multiple kinds of settlements, multiple kinds of dispute resolution methods, and we need to choose the more appropriate for each dispute. And this discussion on mass tech claims is headed on the direction. We need to define which kind of dispute resolution is better suited to provide to settle that dispute and provide, so to say, justice in that specific case.
Exactly right, Andre. I think that the question is this, I think that a lot of the arbitration legislation in many countries doesn't go into how consumer arbitration should be handled by the courts, and perhaps the future of amendments to arbitration legislation in many countries will be to make that kind of provision. Maybe, perhaps, I don't know. I'm just raising the question. Ricardo, you were going to give us some of your thoughts on this as well, please.
Just to make a point, Celso, what you said about the institutional framework. Now we have in Brazil a new initiative on that. So under Brazilian consumer protection law, it is the responsibility of the agencies and departments of the public administration to promote the creation, support, and support arbitration centers with the aim of settling consumer disputes. And there have been a growing number of initiatives aimed at the conception of multiple instruments for the solution of controversies, such as one carried, and that's really, really interesting, was carried out by the National Consumer Secretary, so called Senacom. At that time was headed by former President Juliana Domingues, is a good friend of mine, through a consumer arbitration center. And the use of a website, so a platform. So the website is a platform, consumer.gov. And this platform is used for conciliation, as a conciliation tool, working in the model of out-of-court negotiation systems, including arbitration itself, and transforming it into a multi-door online conflict solution system of the Brazilian government regarding to consumer claims. And the question would be, for us in Brazil, will this platform absorb the mass claims on consumer law and tax disputes or not? And we cannot answer that yet, but it will be quite nice to observe if this kind of initiative could in some way bring arbitration away from the mass claims before courts, for example.
Wouldn't this be great? I mean, this is such a challenging field in which we're moving. And while answering many questions, other set of questions are raised. So it's to me, it seems like a never ending. And I would like to pose a last formal question before we open for questions from the audience. And this would be, do smart contracts need enforcement? And if so, is arbitration suitable? In that sense, I would like to first give a word to André, who I know has been researching and writing around the subject, and he has a super interesting article that I will recommend to you. So André, please.
Yeah, thank you. This is really my pet theme of research now. The smart contracts and dispute resolution and smart contract enforcement. It's my field, my current field of research and writing. And we need to settle some premises as the definition of smart contract. What is a smart contract? A smart contract is a snippet of code that self-execute predetermined instructions. And the smart code, of course, the smart contract, of course, is deployed in some network that could be of DLT, a blockchain network, or could be a centralized network. There are differences between this kind of smart contracts and characteristics of this contract depending on the network, depending on the technology that they are based. We can talk about smart legal contracts that are contracts that are legally binding, that are transferred or translated to code, and that could be only in code, that could be written on legal prose and translated in code, or that could be a mix of legal prose and code. Some scholars call this the Ricardian contracts that mix the legal prose and the code. But in any case, in any this kind of dispute, when we think about self-execution, there's not very a lot of room to discuss enforceability of a smart contract. Disputes usually arise from problems with the code or bugs in the code, or with differences between the code and the related contract. In this case, we have the translation from the legal prose to code, and could arise also from the interpretation of the concrete results from the code self-execution. And this mix of disputes, and there are, of course, they may arise from another set of things, but these examples show us that it's difficult to have to need the enforceability of a smart contract. And one question that we can pose in this field: is it possible to avoid or block self-execution of a smart contract? Arbitration is suitable to block the execution of a smart contract. It seems implausible to block execution of smart contract by arbitration or even by traditional court orders, because the code will self-execute in the network. It will self-execute on the technology basis in which the smart contract is deployed. And what kind? And then we need to ask what kind of alternative remedies the parties have to deal with smart contracts. Usually are remedies after the deployment and the self-execution of the smart contract, but there could be remedies that are previous to that, and depending on the nature of the dispute. And one question or one thought that we can after thought about: an arbitration award could be deployed in code to ensure enforcement. Then we mix the ideas of smart contracts and arbitration, and we internalize and we translate the arbitration award and to code to ensure enforcement. Of course, this is more related to as we say, digital assets or crypto assets, in which the assets and the goods, the dispute is arising around a specific digital good. When we resort to reality, we can auto execute a smart contract, and we will not have the same results in reality. So we have some limits. That this is my impressions on this.
Thank you, Andre. So again, one question poses more questions, and thank you for reframing also. Very, very challenging things expect us in the future. Matthew, what are your thoughts about this?
Well, I agree with absolutely everything that Andre has just said. I mean, look, when everything works, of course, smart contracts don't need enforcement. They are self-enforcing. So what we're really talking about is circumstances where things haven't worked. The usual ones, of course, are precisely the circumstances Andre has raised. Bugs in the smart contract, disputes over the interpretation of smart contract, where you have Ricardian contracts and so on and so forth. A sort of you made quite an interesting question of whether, where you have terms that are in code and terms which are in natural language, is there a conflict? If so, what did the parties intend? Which is binding, the code or the language, or all of that sort of thing. But there are other points. What if you have a contract that works perfectly well, but there's been misrepresentation or fraud in entering into the contract, or an error in oracles, taking data in from the real world? So you have a perfectly functioning smart contract ecosystem that's working on bad data. And in any of those circumstances, you need to do something that the system, by definition, is not capable of doing itself. And it seems to me that that means you need enforcement, and there are two possibilities. One is, of course, as Andre said, you can block execution, but as Andre also said, in practice, you can't, or at least you very rarely can't. So what you have to do is you have to step in after the event. And arbitration is perfectly capable of doing this, assuming there's an arbitration clause in the broader sense, and you get the transaction reversed. Now, a lot of participants in this sort of field will say, but you can't reverse a transaction, immutable, and so on and so forth. The smart contract does what it does. But of course, you can, in the real world, you can reverse things. And you do it precisely as Andre says you can. You can deploy code that reverses the effect. And importantly, and this I think is a point that people often forget, you may not even be able to do that. But what you can almost invariably do is something which in practice has the same commercial effect as reversing it. Now, that may not be quite the same as reversing it, but so what? And we've been happy with arbitrations for hundreds of years. And when I get an arbitral award in damages, that is not reversing the harm that has been done. The building that has burnt down hasn't been built again. It's money, it's compensation. It's different, but it will do. And we can do exactly the same on the blockchain with smart contracts.
What a rich discussion. Really, I think imagination gets short when listening to this excellent panelist. Thank you, Matthew. Lizzie, please tell us your thoughts.
I have to confess, I have learned a lot just from listening to Andre and Matthew talk about the technicality of smart contracts. And one point that particularly interested me was the availability of remedies, both on-chain and off-chain. Before Matthew, at the beginning of this webinar, talked about the digital dispute resolution rules, and I think it's interesting that those rules empower the tribunal to make decisions on chain, so they have the power to modify or cancel a digital asset. Another topic I think is interesting is when you do need some kind of enforcement that is off chain. So Matthew already mentioned that, short of if you are not able to reverse the transaction, what are the available remedies that still put the claimant back in the position as if the breach hadn't occurred? And there you have some off-chain implications. And what are the implications of those off-chain issues? So, for example, you might have a smart legal contract that has an arbitration clause, but is that going to be an arbitration in writing that's going to meet the requirements of the New York Convention, for example? And if you have anonymous parties in an arbitration, are you going to have issues identifying bringing legal proceedings against that party, against its assets in a particular jurisdiction? What about the issues when when the counterparty is, for example, a decentralized autonomous organization whose legal status isn't clear under a lot of domestic laws? And here I wanted to flag there's been a very interesting model law that's been created called the Decentralized Autonomous Organization Model Law that's being put out there to look at the legal status of DAOs and the implications of dispute resolution without, one of the interesting points in that model law, they suggest that any arbitral award resulting from an online dispute resolution system against a DAO would have the same effective status as an international arbitration award under the New York Convention. I'm quite concerned by this statement because an award against a DAO might not necessarily meet the requirements of the New York Convention, but certainly what I think the issue raises is we need to think about the off-chain and on-chain.
Thank you, Lizzie. Thank you so much. Lots of challenges on the way. And finally, Ricardo, please.
So as I am the last one to speak to the last question, I would like to thank Celso for the organization, and Carmen too was really grateful. The organization gave us certainty, and I've learned a lot from all of you. And just to frame again the comment from Matthew, maybe I'm taking Matthew wrong, but his point was what the code can do and what the code cannot do. And maybe it's left for arbitration what the code cannot do. And smart contracts based or deployed on blockchain have the advantage of providing legal certainty to economic transactions. However, they cannot do everything. They have some limitation. For example, smart contracts are sufficient smart to self-execute as programmed, but not to deal with situations where subjectivity is involved. And I think the question of Matthew was in one way, so the comment of Matthew, maybe I'm misunderstanding him, but I hope in a productive way. I think so. Smart contract can generate legal certainty in one side, but what is left behind in all of these matters where the code cannot cope with generating legal certainty is a room for arbitration, for even court decisions, and we will see what will be the results of this uncovered legal certainty by the code. Thank you again for the invitation. Thank you, Celso. Thank you, Carmen.
I'm afraid, Ricardo, you're not going to get away so lightly. There are questions, more questions now. We're going to open for questions from the audience. But before I do, the comments were so interesting. I think you made some comments. I think I should give Matthew the right of reply on this. Because
Celso, I can do this shortly. I agree with Ricardo that there is room for arbitration. There is even room for court processes. I think we have to separate out, don't we, the question of whether you have something which can be resolved within the ecosystem of the smart contract world. Some things can be, some things can't be. But then there's a different question, which is once you've decided that you have something which cannot be resolved on the blockchain itself, because, for example, there is no appropriate dispute resolution process on chain, and because what you're discussing is, let's say, a bug or an alleged bug in the software or misrepresentation in entering into the contract. Let's say you're in that world. You then have, say, an arbitral decision, you have an award, or you may even have a court judgment. Then the question is, what do you do to enforce? And at the enforcement stage, it seems to me you can then often go back on chain to deal with enforcement. You can write some code. You can order code to be written and deployed, which reverses the commercial effect of what happened previously.
Yes.
So I think we're all vehemently agreed.
Yes, we are. The difficulty is because we are necessarily not focusing on any specific industry or on any specific product. tech product. I quite liked Lizzie's comment on what about an in-chain dispute resolution system that spews out an award. Would that then be a New York Convention compliant award? Probably not. But what everybody is mentioning here is, okay, but you can always have depending on the type or the nature of the dispute, you can have an in-chain coded opportunity to repair errors or amend errors, but sometimes you don't, as you were mentioning the question of misrepresentation or when there is a bug in the system. So all of that, all of these are very interesting questions that will have to be addressed in future, depending on the type of industry. Now, what I was going to give more time for those who are watching to come up with questions. Before I go to the questions that anyone who is listening may have, I think I'm going to go back to the cryptocurrency exchange type of dispute, because we didn't have quite enough time to explore the consumer issue questions specifically addressing cryptocurrency exchanges, which is, as Matthew pointed out, it may be very advantageous for a consumer to have an online dispute with an exchange that is based outside his country, outside his jurisdiction, that goes to arbitration, because then that for instance, it may be cheaper, it may be confidential, which is advantageous, and it may give the consumer the advantage of enforcing that award in the country where the cryptocurrency exchange may exist. The problem is with the may exist part, and that's the question that I have for you. Bearing in mind how cryptocurrency exchanges are set up, that is difficult to find out where they are regulated, whether they are regulated, where their assets are, and where the payments for the purchase of the digital coin takes place for different exchanges. How do you see this world of dispute resolution against, in disputes against exchanges developing in future? You don't have to talk too much because it's difficult to you're going to have to speculate wildly here. But I wanted to start with Matthew just to put him on the spot.
Oh, thank you, Celso. I think, look, again, it all depends, doesn't it? Where you have low-level purchases from dodgy exchanges, I think this is where regulators need to step in. You just can't have consumers being let loose in circumstances where they stand to lose, for them, large amounts of money, but from a commercial disputes perspective, small amounts of money, and have to unpick where assets may be, where entities may be that they may be able to sort of enforce their rights. Where it's all too complicated for a consumer, frankly. Where you have more sophisticated people who may be consumers only in the sense that they're not trading, but actually are perfectly able to look after themselves, the sort of the high net worth types who fancy investing in crypto, you've got to do your due diligence. And sensible people won't put large amounts of assets into dodgy wallets held with counterparties whose corporate structures they can't understand in entities that they don't know. They're going to go for the big reputable providers, or if they're more sensible, they'll go for insurance-backed, custodian-mediated approaches to buying their assets. So I think before we get onto the whole disputes thing, people just need to be a bit wise up front, frankly. So now making that point has bought me a little bit of time to think about what the actual answer to your question is. And I think that the reality is that there is at the moment no clear answer, because as you say, if one is going to go, I'm not going to name any exchanges. I don't want to be sued, and I don't want to, well, there won't be an arbitration commenced against me. But if you are going to deal with counterparties who are set up in a slightly flaky way, then you have set yourself the task, haven't you, of wondering what to do if it all goes wrong. Your first question is whether you have any contractual rights at all that are worth anything. And depending on the proper law, forget jurisdiction, let's look at the proper law of your contract. Do you actually have rights, or do you have exclusions of everything relevant which are going to be enforceable? Because if under the proper law, you have exclusions of everything worthwhile, which are going to be enforceable, it doesn't matter where you can arbitrate or where you can litigate. You're going to get zero back at the end of the day. Once you've solved that problem, you can then look at the arbitration clauses and worry about jurisdiction clauses for enforcement. But I mean, often the state of the market at the moment, it seems to me, you're either in a world where that isn't a problem because you're dealing with someone reputable and properly set up, or you're dealing with someone where it is a problem, and where you are, really, your jurisdiction is almost a second or third order problem.
Yes. That's true. I wanted Lizzie to contribute on the answer, but again, I think you're very wise, Matthew. Let's not mention any specific exchanges by name. But Lizzie, what do you think? How do you see this area developing?
I would just agree with everything that Matthew has said. That really users need to be careful about where they're investing, where they're putting their assets. Yeah.
Yes. Ricardo, what is there any European Union angle on this that we should explore?
That's a good question, Celso. I would just agree with Matthew what he said, and I'm not aware of a German approach to that. I don't know if you have some experience in German with this kind of this kind of theme until now, but I agree with Matthew with his comments on that.
Yes, I mean the difficulty, I think, is that there are many different jurisdictions trying to be attractive regulatory jurisdictions for the cryptocurrency exchanges so that they can set up there. But that sometimes it means very light touch regulatory oversight. And that can create problems in terms of consumer protection. The other issue is, sometimes the less reputable operators or the startups occasionally may be set up in one of these very attractive low regulation jurisdictions, and at the same time take advantage of the banking system in better regulated countries to give a veneer of respectability where the consumers can be deceived. And I think it's a question of time. My view is a question of time until the European Union comes up with a more interventionistic approach to the regulation of exchanges, so that there is some type of passporting rights, and they are treated in the same way that any financial services institution is treated already. So that will be, so that then they have the responsibility, the respectability, because there is a possibility of consumer protection, and I think that's how it will. That's my view. Crystal ball moment. But Andrea, do you? I was going to ask you. Sorry, go on.
Just a comment on that. I think it's not yet in a formal horizon from the European Union, but will be soon. So we have now the Data Act, the Artificial Intelligence Act, we have the Digital Services Act, we have the DMA. So all kinds of digital regulation are being taught in Europe. I don't know if it's good or bad, but I think when this became a big theme, and the digital regulation will be also in the agenda of the European Union. So I don't see at the moment a kind of experience like in data protection or in the market regulations, but I think in the near future will be the case.
Yes. Andrea, sorry.
Yeah, no, I agree, and thank you, Ricardo, for complementing the discussion, complementing with your ideas. And we have two sides on this discussion. European Union with the MiCA, markets in crypto assets discussion. United States also is discussing the regulation of crypto assets and exchanges. Brazil is also discussing. The Brazilian Senate has just approved a bill on this subject that will be reversed for the representative chamber. And everywhere we have some kind of discussion on regulation, and all the disputes in regulation relates to consumer protection, financial consumer protection, protection of the financial system, and also tax regulation. And these are the main preoccupations on the regulation on exchanges. And on the other side, we have the idea, and we can say that there is a paradox, there is a contradiction. We have people who invest a lot in crypto assets that want and need, and that has an ideal of the total decentralization. This same people, when they are put behind on there are problems with the dispute dispute with the exchanges, they need a central point to go after the exchange. So as high the decentralization is the more difficult is to make our dispute or go after the exchange and afterwards and to enforce your award. So there's a kind of paradox, and I think all the legislation, all the regulation all over the countries, all over the regions are trying to tackle with this problem in more or more restrictive or more laxer views. And in any case, this will be also resolved by market. Usually, and we say there's a market for banks, there's a market for exchanges. You don't put your money on shady banks, on banks that you don't know how they deal. Usually, you put your assets, you put your money, you put your trust in respectable institutions. This will be the same with the exchanges. The decentralization idea is good, but they will need to centralize to provide trust for the consumers, for the users of the platforms.
Thank you, Andrea. Very interesting. There's one question that was, I think there is only one question that was sent to us. But before I do that, I just wanted to ask Carmen if she would like to raise any questions that you think might be interesting for the panel. We probably have another 8 minutes or so.
Well, actually, I have many, but I would like just to take this space, and thank you, Celso, to congratulate everybody for the interesting debate. I think we could make a part 2 of this webinar, because there are so many unanswered subjects already written down, lots of things, but I don't want to stretch the time right now. So let's go to the question that we have at the Q&A, Celso.
Okay, there is one question which I think I'm going to have to change it slightly. The question is there a main law about international arbitration as we have in Brazil? If there is, which one is it? Of course, we all know it depends on jurisdiction by jurisdiction basis. Every jurisdiction will have a different applicable arbitration act. But the interesting question behind here is, should there be amendments? Is that necessary to have amendments to the big recognition of awards convention, which is the New York Convention, to take into account tech disputes? I'm going to, for once, not pick on Matthew and start with André instead. What do you think, André?
Yeah, I think that New York Convention probably will need to be amended to be able to have all these new kind of dispute ODR systems and all new the kind of dispute resolutions in order to be recognizable and enforceable in the signing countries. Nowadays, all the tryings and the tentatives of bringing ODR awards to an enforceable arbitration award according to New York Convention always pass through shortcuts and and schemes to shortcut and the problems and the incompatibilities. And probably New York Convention has some years in what was enacted some years in the past, was signed, was edited a lot of years ago, and the reality now is very different. I think that the amendment of New York Convention or a new convention on tech disputes could be a solution for some kind of discussions and some kinds of problems that arise from this new kind of systems for dispute resolution.
Yes, and this is a difficult question, isn't it? Because we are really trying to look crystal ball-like into what is it going to be happening in the next 5-10 years. But Lizzie, I'm afraid you set the hair running on this one. So you're going to have to tell us exactly, expand more, please, on when you mentioned the New York Convention. Automatic awards that may be raised that may not be compliant with the New York Convention. Perhaps a solution is then to amend the New York Convention. What do you think?
I think that the New York Convention exists as a gatekeeper for protecting due process in international arbitrations. And in our practice, we have generally come to expect a very high standard of due process for international arbitral awards. And there are other concepts underpinning the New York Convention, for example, the idea that arbitration probably is to some extent localized because we put so much emphasis on the courts of the seat in deciding whether to recognize or enforce an award. And in many jurisdictions, an award that has been set aside by the courts of the seat will be null and invalid in every other jurisdiction in the world. I think there is a question as to whether some of these assumptions are going to continue to hold true for disputes that are resolved by processes that might not meet that high standard of due process or may be decentralized. So what are some examples? It would be, what if you have a reference to a decentralized justice system that actually has no seat? Would any award, presumably any award resulting from that kind of system wouldn't meet the requirements of the New York Convention. Some decentralized justice systems don't have an arbitrator that makes a decision based on the application of the law to the facts based on their experience and opinion. So, for example, Kleros has jurors who make decisions and they're incentivized by crypto incentives in the sense that every juror puts in a stake of tokens in order to decide the dispute, and jurors are rewarded by tokens if they make a decision that's consistent with the majority, and those jurors that don't make a decision consistent with the majority lose their tokens. It's just a totally different way of reaching a decision, which to some users who choose it may still be fair. I'm not sure about is whether we necessarily need to amend the New York Convention to accommodate these different ways of resolving disputes, or if we just need to think of a different system altogether. And then, just as a final point, I do think it's worth considering whether smart legal contracts containing arbitration clauses would meet the in-writing requirement under the New York Convention.
Thank you. I think we are running out of time. Matthew, would you like to add anything?
I'm happy to say that I agree with Lizzie. I don't think I do have anything to add this time. The in-writing requirement is an interesting one. So is a duly authorized award. So I think there may be problems with the New York Convention for some sort of some so-called arbitration awards in the sort of schemes we've been discussing. But can I, again, reality check, we're not going to change the New York Convention, or at least not in the short term, not in the medium term, possibly not in the long term. So the short-term game seems to me to structure your exotic dispute resolution processes in such a way that they at least stand a fighting chance of being arbitration awards.
Thanks, Matthew. I agree. And Ricardo, any final thoughts?
That was a kind of tricky question because it brought maybe the purpose that why we are together today, you know, to think about tech disputes and in which way tech disputes is related to normal arbitration disputes. And it was quite interesting to see that we just closed the circle with the question that we began with. I'd just like to thank you, Celso, for the organization, to you, Carmen, to Andre, to Lizzie, and to Matthew. It was a great pleasure to be here with you.
No, thank you, and thanks everyone for their contribution. I will pass it on to Carmen now, the floor, please.
Thank you, Celso. It was a pleasure for us to have you here today and to nurture ourselves from your knowledge and from the questions posed that, as I said, open even more questions. One last thought that came to me while listening to the last comments, especially when we think of consumer disputes, would be very important, especially in countries like Brazil or, you know, not so developed countries, that in consumer disputes, we make sure that access to justice is made to every kind of consumer, because when we speak about technology, we know that not everybody has access to internet in our side of the world as many other places. So that is also a challenge that I would like to pose, because we are concerned of the practical legal issues and enforcement and what you have, but something we should never ever forget is that justice should be accessible for everybody. So with this reflection, I would like to thank you all and wish you all the best, and hope that we have a second chapter of this amazing webinar.
Thank you very much. Thank you.
Thank
everyone.
you, Carmen. Thank you, Celso, and my fellow panelists.
Thank you so much,
Thank you.
everybody.
Thank you. Goodbye.
Bye-bye.
Bye.
Bye-bye.